Right. Good morning. Sorry for the delay.
Good morning.
Good morning.
Sandridge, you're up.
Thank you. So if it may please the court, my name is Hala Sandridge. I represent the petitioner landowners. I'd like to reserve 4 minutes for rebuttal. We are here because the circuit court failed to apply Florida law that requires courts to apply specific comp plan provisions over general ones and to give effect to all provisions in a comp plan. By failing to apply these rules, the circuit court applied the general compatibility requirements contained in the Hillsborough County Comp Plan, policies 16.8 and 16.10, rather than the exception for the RP2 land use category, which used Objective 33 and Policy 33.2. Those achieve compatibility through its planned village design elements. The circuit court also applied requirements totally absent from the county's plan or code. For example, the circuit court stated that the county staff failed to analyze the effect of the proposed development on the surrounding area. And the circuit court also stated that there had been no showing of how the compatibility of the development would serve to prevent urban sprawl. Apparently, believing that the effect of the proposed development was a required analysis, the circuit court then cited incompetent testimony from community residents that did not address compatibility under the planned village policy, but under general policy compatibility requirements. However, neither the plan nor the code.
Do you have a case, Ms. Sandridge, that says that that was wrong? I mean, because it seems to me that what the judge was saying, I mean, he did in his order mention the testimony or complaints or the presentation, I guess, of local residents, but he also got very specific. So he pointed to figures in the record that said this would cost 12,000 trips a day on this, what the report says is a substandard 2-lane county road. And my reading of the order is that this was evidence on which the county commission could say, you know what, we're not going to do, we don't have to do this. And my reading of your argument seems to suggest that if county staff and planning commission staff and the hearing officer say, well, this satisfies the RP2, the village, that you are automatically entitled to this. But couldn't the county commission say, look at this and say, if the number of residences were going to be half, it complies with all the requirements, but the number of residences in this development were going to be half, so perhaps the trips down the road were going to be 6,000, we'll approve it. Can't they do that?
No. So here is the no.
So you can go right to the cap under the RP2 and you are legally entitled to it. That's your position.
No, that is not our position. So let me start at the beginning with Snyder. Snyder requires us to prove that our rezoning request is consistent with the plan.
Yeah.
So that's our initial burden. And once we show consistency, then the burden shifted to the county to show by competent substantial evidence that there was a reason that they could deny it. So we are not entitled. We are not entitled. And that could be a reason. It could be that there is
12,000 trips a day, 12,000 additional trips a day on this county road.
That they might find it to be too much. But it has to be related. Now, let me make clear what Snyder says. And I think this is a real important part of Snyder that is consistently overlooked by both the county and the circuit court. And I'd like to read to you what Snyder says, the burden that shifts. So it is that maintaining the existing zoning classification with respect to this property accomplished a legitimate public purpose. And this court and other DCAs have made clear the county doesn't simply get to identify a policy. It has to show by competent, substantial evidence that maintaining this existing zoning with respect to this property, it doesn't matter that they identify a policy that they like. They have to show that with respect to this property, it accomplishes a public purpose. All right.
You would concede, Ms. Sandridge, that generally speaking, and specifically under the comp plan, that preventing urban sprawl would qualify as a legitimate public purpose. You would concede that.
I will concede that under the comp plan, urban sprawl is a legitimate public policy, but
hold that thought, Ms. Sandridge. We may have lost Judge Northcutt. Judge Northcutt, are you there? Can you hear us? No.
Judge, it looks like he may have dropped off again.
Okay.
1 second.
And just to keep fresh in your mind, Ms. Sandridge, you were just pivoting, talking about you had said yes that
urban sprawl is
a legitimate public purpose, but and we're all waiting to hear what the where that goes to.
The longer Judge Northcutt is gone, the greater the anticipation. You're muted, Judge Northcutt, or it's not coming through.
You can't hear me?
There you go.
Now we got you.
Not only do I make an entrance, I like to make a bunch of entrances. Never had.
Ms. Sandridge, we are all waiting with bated breath.
Your sound keeps, just a fair warning, Judge Northcutt, your sound keeps cutting in and out.
I don't know what to do about it at this point. I'm trying.
Okay.
Sandridge, I'm going to wind you back. That's okay. Sounds fair.
Thank you. So I was just about to answer the question.
Hold on, Ms. Sandridge.
Did we
Looks
lose
like you
him?
may have dropped off again. Yes.
Oh dear.
Judge Northcutt's been having some internet problems, and I understand here at the court there may be some issues as well.
I don't know if y'all have heard, but there's a national problem with Comcast. It's all over the news. And so I know our firm has been having some problems too.
Hear me?
Barely.
I'm going to try to keep. I was saying that I will add another 3 minutes to your time.
Judge Northcutt, perhaps if you sign off and sign back on, it's really not, your audio is not coming through.
All right, let me try.
Wait. Right now, you hit it.
So, if I hold the phone in this position for the next 2 hours, you can hear me.
It'll be fine, yeah.
Let me try to put this up. Can you hear me?
Mm-hmm.
Softly, but yes.
All right, Ms. Sandridge, I'm going to wind you minutes if that's. I think everybody thinks that's good. Okay.
Yes, I'm losing you a little bit, Judge Northcutt. I think you said you're going to wind me back. Can't hear him.
Steve, yeah.
How's that?
Perfect.
Okay.
Apparently, perhaps when you're putting the phone down, it's covering the mic, and now your audio and video are gone. You're okay.
Okay. Can you hear me?
Yes.
Sorry. All right. I'm adding 5 minutes to your time here, Ms. Sandridge. So where that left off, you were at about 7 minutes.
Thank you.
Trying to keep back. Okay.
Thank you. So I'm going to go back and answer the question that was posed to me by the panel. And yes, avoiding urban sprawl is a valid public policy. There's no question about that. But in order to determine whether our rezoning was avoiding urban sprawl, you have to apply the correct plan policies. And that was the problem here, is that even though recognizing that the RP2 with its planned village design is an exception to compatibility and to urban sprawl, the circuit court and the county argued that you should look to the compatibility requirements of the general plan.
See, and that's where I want to maybe drill down a little bit, because I don't know if this is intentional or if it's just maybe what I read in your argument, but it leaves the impression that your argument is essentially, look, RP2 planned village is a specified exception, which the whole purpose of which is to minimize and prevent urban sprawl. Okay, am I correct so far?
The design of it.
By design.
Mm-hmm.
And therefore, and this is the leap that I would maybe try to drill down a little bit on. Therefore, by definition, this must, or at least be presumed to mitigate or prevent urban sprawl. It seems to be the other shoe that falls here, and that's the reasoning that I would question, because it's a little bit like saying the purpose of building a monorail is to diminish traffic, and so therefore any monorail must be presumed to diminish existing road traffic, which we know to be demonstrably incorrect. So the fact that you have an RP2 design, depending upon the surrounding circumstances, it may decrease urban sprawl, but it might not, right?
So you have to look at the design elements, and that is, you're correct. Just because we offered up a planned village design, did we comply with all the elements? So let me give you an example, I think, of evidence that would have shown that we didn't comply with the planned village and we're going to cause urban sprawl. And you know what, let me go back and talk about the definition of urban sprawl, because I think that's really important here. I get the belief that the county is kind of advocating that urban sprawl is just simply building in a rural area. That is not the definition of urban sprawl. So let's look at this and break it down. It's a development pattern characterized by low density, automobile dependent development with either a single use or multiple uses that are not functionally related, requiring the extension of public facilities and services in an efficient manner, in an inefficient manner, and failing to provide a clear separation between urban and rural uses. So that is what urban sprawl is. That's the statutory definition, 163316452. So what we're saying is that when the county and the state settled on this planned village design, it was designed to avoid this. So then the question becomes, did we present evidence that complied with those design elements? And by the way, they're set up in the plan. So for instance, you have to have a certain amount of feet to have a buffer. You have to have a certain percentage of retail. You have to have a certain percentage of commercial. There are all sorts of requirements in a chart. If somebody came in and said, look, this buffer is only 150 feet, or if they came in and they said, you know what, they don't have the appropriate amount of retail, or their trip capture ratios, which is the ratios of cars that are going internally, that's false. Here's the study that shows they're wrong. Then I would agree with you, Judge Lucas, that we didn't carry our burden to show that this wasn't going to cause urban sprawl, but we did. And we satisfied this definition. So let me go through this. This was not going to be low density. It was not going to be automobile dependent, as shown by our trip capture ratios. This was not going to be multiple uses that were not functionally related. We were not going to require the extension of public facilities and services. That's a big part of why we don't want to have urban sprawl, is because we don't want to extend out public facilities that are so precious to our county and our city. And we did provide a clear separation between the urban and rural uses through the buffer and also through these big, wide open areas. So, you know, here we have a formula that we completely satisfied with no contrary evidence to show that we failed to comply with the planned village, which was developed specifically to not have this development pattern. Remember, that's what this is. Urban sprawl isn't just the existence of a lot more building going on in a rural area. It's an inappropriate development pattern. So it's our position that what the circuit court did is it ignored the case law that says that it was required to apply the specific provisions of the plan over the general provisions of the plan. And
to
here,
do what? To do what?
To analyze whether or not we had competent substantial evidence. So that's a good question, Your Honor. So,
Yeah.
so our point is, you know, when you're trying to determine whether we satisfied our burden of showing consistency with the plan, you're looking to see whether there was competent substantial evidence, which then shifted the burden over to the county. So when the circuit court was reviewing this for competent substantial evidence, it had to apply the specific comp plan that it was looking to see if there was evidence that satisfied our burden. And he did not. He did not. He recognized, it's odd, he recognized that it was an exception to compatibility, to density. But then he went and he applied the rules, the general rules related to compatibility in the comp plan. And by doing that, he effectively did what the county wanted him to do, which was to write this specific land use designation out of the code. If we do not allow this planned village concept to be utilized and reviewed under its intent, then we're effectively saying you can never have a planned village concept.
Ms. Sandridge, the concern that I have, as you might imagine, is the limitations on second tier review. And the trial court, in reading the order, seems to have taken into account the applicable law. And I understand you're saying, well, the judge misread certain aspects of the case law, but we don't typically get to correct what is an incorrect application of the law. We get to correct a failure to apply the law, failure to consider the law. And so I think, at least for me, you need to address that and persuasively address whether or not this is meeting our second standard tier. And I have trouble with the standard, as I think many judges do, when you look at specific facts of a case. But it is a pretty strong limitation on what we can do in terms of not correcting mere legal error.
Sure, and I was very aware of that standard going into this appeal. Second tier cert is a difficult standard. I acknowledge that. But here, let me be clear about what the circuit court judge did and why it fits within that second tier standard. So this is not just applying the law incorrectly. This is not applying the law at all. And so in my petition that I filed in the circuit court, I made this argument and I cited the case law that said that the exception controls over the general, that the specific controls over the general, that you do not read out a specific code section. You're supposed to honor all the code sections and give them all effect. And the circuit court judge just ignored it. He didn't.
No, I'm not sure that's what he did. I think what he said is that he, as he understood your position, once you showed those things, that's all that anyone got to look at, and that so you're in like Flynn just by satisfying this list of criteria for planned village. And he said, no, that's not true. And so he didn't disregard the law or fail to apply the law. I think you might argue that he erred in his application of the law.
So the reason I say that he did is because he didn't cite this law. He didn't acknowledge it. He didn't recognize it. And when I say this law, let me be clear about what I'm talking about. I'm talking about these rules of statutory construction, which apply, and I don't think there's any disagreement on that, within the scenario of a plan or a code, that you give effect to the specific over the general. That's what he didn't recognize. That's the rule of law that was, I don't even know what to call it, because he didn't even mention it. He avoided it, he ignored it, but he certainly didn't apply it.
All right, by my timekeeping, which of course at this point is quite wonky, I have you down to 4 minutes. And so if you want to preserve them for your rebuttal, just give me
I would like to. Thank you.
Okay, cool. All right. And now, okay, fine. Ms. Schrader, you're up.
Yes, thank you, Your Honor. Good morning, Carly Schrader of the law firm Neighbors Giblin and Nickerson, here on behalf of the respondent, Hillsborough County. In this case, the county's asking the court to deny the petition because the petitioners at this point in their briefing and in their argument have failed to show any violation of the central requirements of law that amount to a miscarriage of justice here. And I wanted to focus kind of on the big picture here. And then the standard that the circuit court is operating, that has the three parts that it looks at as part of its standard of review. And then that's narrowed when it comes to this court for review. And this is not a case similar to some of the case law that's cited by petitioners, where the circuit court did a de novo reweighing of the evidence. That's not the case here. This is also not a case where there's no evidence to support the decision of the county at the end of the day. And so the circuit court applied the correct law, applied the Snyder burden shifting framework in looking at the decision of the county as to whether petitioners have met their burden. And then if so, whether the decision is supported by competent substantial evidence. And the court did not err in reviewing the case under that standard. And also wanted to point out to the court that what the petitioner overlooks in this case is this is a rezoning decision where there's an increase in density that's requested. And under the case law that applies where there's a density increase that's requested as part of a rezoning decision, it's appropriate. The county has discretion in making those choices, particularly where the existing zoning category is supported in retaining that, where it's also consistent with the comprehensive plan. And that is
the question that I asked Ms. Sandrich about, the daily trips on the road, and would that have been affected by if the landowners had come in and said, we don't want 900 units, but we want 450, and of course that obviously would cut down on the trips of the road. So since this is an increase in density, is that the sort of thing that the county commission could look at and take into account in its decision?
The county can look at those impacts to surrounding property and to the character of the area, including by the increased trips, like the circuit court noted, that 12,000 additional trips that rezoning the property would put on the roadways. And that is appropriate to look at in looking at the consistency with the comprehensive plan and compatibility with the general area in terms of this great increase in the traffic that's placed on the roadways as part of that decision. Or as part of that application.
And that would be even though the landowners had satisfied the specified criteria for the RP2 zoning.
Yes, I think the argument is that they met the design criteria, so therefore the analysis stops and you don't look at anything else. Under the provisions of the comprehensive plan, though, even under policy 33.2, they have to meet the intent of the planned village concept. And the intent of the planned village concept is to avoid urban sprawl. So these are all interlinking provisions. The goals, the objectives and policies of the plan overall, one of the major purposes of the comp plan is to avoid urban sprawl. And it's accomplished through the objectives and policies within the comprehensive plan, including that the planned villages meet the concept of demonstrating that they don't increase or they don't bring urban sprawl into the area. And here, so that's an appropriate thing for the county to have looked at. Also appropriate is protection of the existing neighborhood. This is written into the county's comprehensive plan as well. And in fact, the Planning Commission report that sets forth the applicable provisions of the plan lists out Objective 16 and its underlying policies that talk about protection of the neighborhood. Here, it's really important to look at the context of where they are asking to place this development and have this large density increase. And the case law in this area where there's a density increase that's requested as part of rezoning talks about the county having, or the zoning authority having a choice between alternatives where they would both be consistent with the comprehensive plan. And what is appropriate evidence to look at for that competent substantial evidence includes the county commission looking at consistency of the proposed project with that adjacent property and the actual development that's part of the area. And I don't think it's disputed in this case, the area in which they're asking to develop this property, the immediately adjacent area, is zoned exactly the same as the existing zoning, or are zoned or are placed in a separate zoning category. That's a 1 per 1 acre. That's still underneath the density that's requested as part of this change. And under those circumstances,
Ms. Schrader, you would acknowledge though that the conclusion, what you are advocating and the conclusion that the commission reached essentially relies upon the same evidence and the same data that was before the zoning hearing master, the Development Services Department, Water and Wastewater, Hillsborough County School Board, HART, Transportation Staff, the EPC, all of which concluded that this rezoning would be consistent with the comp plan and wouldn't pose a problem, at least from their perspective purviews. What was different between what was before the zoning hearing master and the commission such that they came out in a 180 in a completely different place?
so the land use hearing officer just makes a recommendation to the board, and the board
Right.
looks at that same evidence and can come to a different conclusion. That's supported in the case law. The county
Granted, but what data? I mean, when you have a line of agencies that are tasked with reviewing these applications within the purview of their respective portfolios of expertise, and they're all coming out that this is consistent with the comp plan, this doesn't pose a problem, but it goes before the commission, and the commission, and then on first tier review, the circuit court conclude, yeah, it actually does. It is somewhat of a stark turnaround. I mean, you would acknowledge, wouldn't you?
I don't think this is unusual in zoning case law. If you look at Blumenthal, if you look at other decisions like that, there were recommendations in those cases alternatively to what the zoning authority ended up doing at the end of the day. It's not, it's within the county's discretion to make the choice that it made in this case. If you look at the Metro-Dade County versus Blumenthal case,
Well, to be clear, it is not an unbridled discretion to deny a rezoning application if the comp plan is being followed. That landowner has certain rights, and to say, well, the county has discretion whether or not to grant it or deny it, I think maybe cutting some short shrift. Don't you think?
so their discretion is constrained by the comprehensive plan and those
Right.
goals, policies. Yes, that is true. But where the zoning request is also consistent with the plan, the case, and you look at the surrounding property and the impacts on those properties, that's always part of a rezoning analysis. And here, the surrounding land use is undisputed. It's rural, it's agricultural. It's at a much lower density than what they are requesting to go to. And there hasn't been an analysis that was submitted that talks about where you have such an
Well, I
increase
think
in
what
the
Ms.
traffic.
Sandridge's response to that would be, and I'll let her speak, is look, every RP2 rezoning is going to result in increased density. That's what it does. That's how it fulfills its purpose to mitigate urban sprawl. So I get it. The tenfold increase in density. I mean, you can boldface it, and it does seem to pop out. But you could flip the coin over and say, well, that's the whole point. by increasing density and by putting all the services within that area, you necessarily allow for development and allow for population increase, which is happening in Hillsborough County. You allow for that, but in a meaningful and in a meaningful way, and in a way that mitigates urban sprawl.
So under the comprehensive plan, under a land use designation, it sets the cap, it sets the ceiling for that density, but there can be different zoning categories that apply different densities that are underneath that. That's the zoning implements the future land use. And so when a rezoning applicant comes into the county with a rezoning request, part of what they're trying to convince the county is that it's appropriate right now to change that zoning to something else. And that's balanced by what is the property that's on the ground? What are the impacts to the physical property and what's already been developed? And the court in this case analyzed the correct standard under Snyder and looked at the trips that were going to be placed by and increased by this, and that there hadn't been a explanation for how that mitigates against urban sprawl. That is the intent of the Planned Village concept, is to mitigate against that urban sprawl. But where you have this vast increase in density, including this trip count, the purpose is designed to protect against urban sprawl. And there hasn't been a showing by petitioner that's protected in this case. And in any event, under that Snyder burden, and even if it shifts to the county at the end of the day, the issue is whether the lawfulness of the decision is supported, not whether this court or the petitioners would have come to a different result under the same evidence. This isn't a case where there's no evidence supporting the decision. The court can, and the county can look at the surrounding properties and the existing zoning that's on the ground and look at the compatibility and things like, are we protecting the neighborhood? Their Baum community plan is written into the code that talks about the rural and agricultural nature of that property. You did have lay witness testimony that to the extent that they talk about the existing conditions that can be considered. And you have zoning maps, aerials that show the nature of the property. All that can be considered as part of the decision. And under the Blumenthal and the Wahlberg cases that we've cited as part of our brief, the court noted where there's a choice between the alternatives, it's up to the county to make that choice. And where the existing zoning is also consistent with the comprehensive plan, the county has the discretion to make that choice at the end of the day.
Ms. Schrader, I do have one question relating to that. Is there any obligation on the county to send it back to staff and the agencies to say, you have neglected to take into account certain factors that are troubling to us, and you need to reconsider? Is there any ability to do that? And if so, should that have been done as opposed to an outright rejection?
Well, the hearing officer, the purpose of the hearing officer is to take the testimony at the quasi-judicial and take in that testimony. So I don't think there was an obligation in this case to send that back down to the hearing officer, where the record before the hearing officer gave support to the county's decision and had competent substantial evidence to support the county's decision in this case. So it's just where the county felt like it needed more evidence to consider to make its decision that it would be appropriate to send it back down to the hearing officer.
And if that was a possibility, I assume, I don't even know if it's a possibility, but if that was a possibility, it would be a discretionary call with the commission and would be way outside of our scope of review at this point to say the commission abused its discretion.
Yes, I think that's correct. Where the competent substantial evidence supported the decision, that's what the circuit court was looking at the end of the day. The circuit court made its determinations based on the appropriate standard. And this is not a case where the planned village criteria or the design criteria writes out the other provisions of the comprehensive plan. It does not keep the county from considering those broader goals, objectives, and policies.
And in fact, the RP2 definition says it creates this exception where density may be increased, not shall be increased, correct?
Correct. And so
And
under the
and it
comprehensive,
doesn't in itself say what the criteria are for permitting it. I assume that's just a matter of the overall thrust of the plan.
correct. And the overall thrust of the plan is to avoid urban sprawl and to protect existing neighborhoods. And it's important enough they have community protection provisions that, and also the Baum Community Plan describes the vision and goals for that neighborhood and talks about the rural area. And so that's appropriate to take all of that into consideration, including protecting the existing development and that this fits into the nature of the area. All that can be considered. And of course, this court's review on second tier certiorari is quite narrow, and it's just the legality of this decision at the end of the day. And it's not mere legal error that's corrected for, but a miscarriage of justice. And so that's important to keep in mind that this narrow standard that's different from what you would have on a typical appeal. And it's also important to read the plan as a cohesive document and to not read out parts of the plan. All of the applicable provisions have to be complied with, and the petitioners must submit evidence as to all of those applicable provisions in order to get past their burden of proof and for that burden to be shifted to the county. Even if that burden was shifted to the county at the end of the day, it exercised within its discretion to retain the existing zoning category here, where the surrounding property also had the same identical existing zoning category that was in place. And I would refer this court specifically to the Miami-Dade Wahlberg decision, which was a similar increase in density request that the zoning authority denied, and citing that the closest zoning district was the same as the existing versus the proposed district, which was some distance away, and that the change to that higher density would be incompatible with its surroundings. The court noted there is a choice between the alternatives, that they sustain the county's choice. It's the county's choice to make and to weigh that evidence at the end of the day. Also, the Metro County versus Blumenthal case also supports that it's appropriate on a rezoning, a density increase, to look at the zoning maps, the aerials of the existing area, to take that into account when making that decision. And that is competent, substantial evidence that can support the decision where there's a choice between those alternatives. Here, what's really being asked is to reweigh the evidence below, which wouldn't be appropriate here on a second tier. The county does not believe there was any error in the circuit court's decision in this case, and would ask that the court deny the petition.
Okay, thank you, Ms. Schrader. Am I on? Yeah, I'm on. All right. Ms. Sandridge?
Thank
4
you.
minutes.
So I would like to first start and remind everyone, this is a quasi-judicial proceeding. Snyder changed the way we conduct these proceedings. This is not a legislative proceeding. There is no discretion involved. The Board of County Commissioners doesn't get to look at all the evidence and say, well, you know what? I don't really think that I like this, and so I'm going to deny it. They have to look at the evidence and find support for their decision. And it has to be competent, substantial evidence in both our burden and the burden of the county when it has to prove that maintaining it serves a valid public purpose. Judge Northcutt, I want to address what you asked about, whether they could just kill the project outright, or whether or not they could remand it, maybe for a determination of less density. They killed it. And it does have a place in what you consider, and that is the bad faith of the county. When you take a look at the timeline of everything that they were doing with the moratorium and how they killed this project, it does have a place for you to consider that. Let me go to the quasi-judicial point of competent, substantial evidence with respect to traffic. The traffic evidence showed that it was not going to burden the roads. That's what all the experts said, that the roads could handle it. The county commissioners don't get to come in and say, well, I just simply disagree with you. And what they couldn't do is consider general evidence from residents about traffic. As we all know, the case law says that that's not competent to just come in and say, well, there's going to be more traffic. Of course there is. So ultimately, they have to look for competent, substantial evidence to support what the board did. That also leads me to the density increase and the concern about that. Again, I would go to the importance of this settlement agreement that the county reached with the state to try and create this transition area between urban and rural. And they did it by only allowing this type of a planned village development to exist on 160 acres or more, taking care of that feel of packing in a bunch of homes, instead clustering it and having this green space. So ultimately, what we're looking at is, in this quasi-judicial proceeding, was there competent substantial evidence proved by us, proved by the landowners, to show consistency with the plan? And there was. It shifted the burden over to the county, who to this day believes that they didn't have to prove competent substantial evidence in their burden, but they only had to identify a policy. I'd like to close with one statement, and I would urge this court to take a look at a case I cited in my reply brief, Surfworks versus City of Jacksonville Beach, out of the first DCA. It's 2017. The facts parallel this case a lot. When a party complies with the law in seeking to utilize the highest and best use of their property, and the governing authority refuses to apply the correct law, to thwart the citizen so as to deprive him of the ability and right to enjoy the lawful highest and best use of the land, a miscarriage of justice has occurred. So I would ask this court to follow the Surf case, to follow Snyder, to quash the decision of the circuit court that finds that we did not satisfy our burden in the circuit court. Thank you.
Okay. Thank you, Ms. Sandridge. Thank you both very much. We will move to our, in order to keep in mind to leave the virtual courtroom, you need to click the leave button that's on your